evidence, sense the tension in the room, the cameras, and the people that are here. This is not your trial. It looks and it feels a lot like it's supposed to be a trial, but it's really just about the issue of whether or not bail is going to be denied to you in this case. And I am confined to a specific law in Ohio that specifically deals with this issue. And it's worth reiterating those factors that I mentioned earlier to you, because I have something I want to add to each one of those. The first consideration is whether or not the proof is evident or the presumption is great that the accused committed the offense with which the accused is charged. Now, I am to consider what you have been accused of in the indictment. That's what I reviewed with you at the time of the arraignment. And there's 7 different charges in the arraignment, but only a few of them really pertain to this statute. And we've heard the term aggravated murder thrown about a few different times in here, but that's not the only charge against you that could prompt you to be held without bail. It's the highest charge, but it's not the only charge that could trigger this. You have been charged with count 3, felonious assault, and that's a felony of the 2nd degree. That could have prompted you to be held without bail as well. It's part of count 2, really, though, because count 2, which I'm going to direct my attention to, is the offense of murder. In this form of murder that you are charged with, it alleges that on the date of August the 23rd, 2025, that you unlawfully did cause the death. And it says here, child, and we know it's Vincent from the testimony that's here, as a proximate result of the offender committing that offense of felonious assault. So essentially the state's saying, by committing felonious assault, you cause his murder because he died as a result of that felonious assault. And there's different ways that people can be charged with felonious assault. The state is saying in this case that you knowingly caused serious physical harm to Vincent. Ruth, I'm not trying to make it more drama than is necessary. I'm just trying to go through and make it clear to you as to what my thinking is at this point. And that is, I am concluding that the state has presented clear and convincing evidence that the evidence, proof is evident or the presumption is great that you committed the offense of murder at a minimum and felonious assault as a minimum, as you have been charged in the indictment. It's not lost on me that your attorney makes a good point, and that is when he talks about that issue of whether or not you were committing the offense if you in fact were insane at the time, as it is defined in Ohio. We've heard a lot of people in here talking about religious delusions, mental crisis, mental health issue at the time. The truth is, we've all heard a bunch of lay opinions, is all we've heard. And a lay opinion is somebody who's not an expert. There's been an order in this case for you to have an expert weigh in as to whether or not you were insane, just as your attorneys have asked me to do. And that will take place. But it's not going to be a detective. It's not going to be the county sheriff. It's going to be an expert in this area who will tell us whether or not, in fact, you were insane at that time. So as for the first bullet point, I believe the state has met that burden. The next point, the question is whether or not the accused poses a substantial risk of serious physical harm to any person or the community. I'm going to talk about number 3 at the same time. It goes into whether or not there are no release conditions that will reasonably assure the safety of that person and the community. I have to be convinced by clear and convincing evidence that that the state met their burden, that you do pose that substantial risk and that there are no release conditions. To get to that point, the legislature in Ohio, they didn't just leave it up to Mike Ernest to use your best judgment on it. They didn't do that. They said, you have to consider the following. There's four of them. They're kind of long, but I think it's worth going through them. Number one, the nature and circumstances of the offense charged, whether the offense is an offense of violence or involves alcohol or drugs. There's no indication here that alcohol or drugs were involved, but there is also no dispute that murder and felonious assault are offenses of violence. The weight of the evidence, number two, against the accused in this case. I'm going to conclude that the weight is significant against you in this matter, that in fact you carried out the offense of felonious assault and in this case, these for today's purposes, murder. Three, the history and characteristics of the accused, including but not limited to the following. I'm to consider these, and I have. Your character, to the extent that I can, at a bail hearing. Character, physical and mental condition, family ties, employment, financial resources, length of residence in the community, your community ties, past conduct, history related to drugs and alcohol, and criminal history of the accused. I know of no criminal history. I don't know of any reason to believe you don't have a strong connection to the community. I've taken that into consideration. I've taken into consideration the fact that a lot of people, well, I shouldn't say a lot, a number of people who have testified here today, they would at a minimum have raised an eyebrow as to your mental condition on the date in question. I am also to consider whether at the time of the offense, whether or not you were under supervision of any point in time. You clearly were not being supervised by another court at that time. So I've considered it. Lastly, the nature and seriousness of the danger to any person or the community that would be posed by the person's release. Those apply to whether or not you pose a substantial risk of serious physical harm, whether the state has met that burden. And Ruth, in my assessment in this matter, I am coming to the conclusion that the state has presented clear and convincing evidence that you do pose a substantial risk of serious physical harm to any other person or the community, and that there are no release conditions that will reasonably assure the safety of that person and the community. And I'm going to tell you why. In this case, you were told, at least by the evidence that I've heard so far, that there were people in the community who had concerns. The bishop was concerned. Your family was concerned. They tried to intervene. They tried to have you listen to reason with them. And I think by clear and convincing evidence, you did not listen to the bishop. You did not listen to your family. And Ruth, I don't think you'd listen to me if I put conditions upon you in the community. You listened in this case to what you believed God was telling you to do based upon the testimony that I've heard to this point in time. And that does not leave me assured that you will follow my conditions. For that reason, I am going to deny bail in this case. I'm going to have you held in the Tuscarawas County Jail while this matter is pending. The statute, though, it does, and regardless, the issue of bail is one that could be reviewed. And I don't mean to plant any type of false hope that I would somehow change my mind and have a personal recognizance. That's not what I'm trying to do here. But really for the first time, at the end of this hearing, I heard for the first time that there may be a place that you could go to other than the Tuscarawas County Jail for which the community could be assured of the safety of others and that you would not pose that substantial risk of harm to others. And I'm open to that idea. I simply know nothing about that idea at we are just going to have to agree to disagree on this issue. I know you've asked before, but my opinion is this: when someone is being held without bail, and on aggravated murder, I only want to put an order in place that I believe I can enforce. And if she were to make phone calls from the jail, I feel as if there's nothing more I can do to her. She's already being held without bail, facing life in prison. So I don't know what teeth, I could put into it if someone doesn't listen to me. If someone, though, persists in calling from the jail, and you believe they are in some way interfering with this case in some way, I would consider that placing an order with the jail to not allow phone calls to be made in general. But at this point in time, I just simply don't believe a no contact order when there is no bail is enforceable.